Hi, everyone. Either good afternoon or good morning, depending on where you are. Welcome to our webinar, The Office is Calling, Legal Considerations for Return to Office Policies. I'm Gillian Round. I am a partner in Fasken's Labor, Employment and Human Rights Group here in Toronto. I advise both unionized and non-unionized employers across a range of industries on all aspects of labor and employment law. And before I introduce our panel for today, I'd like to draw your attention to a few administrative items shown on the screen here. Please note that the CPD certificate and post-event survey, QR codes and links will be shared at the end of our webinar, so you can complete the survey and access your CPD certificate for Ontario, Quebec, or BC. And we'd really appreciate you taking the moment to share your feedback on the presentation. And with that said, we have a great group of speakers today. So joining me today is Joseph. Joseph is an associate in Fasken's Labor and Employment and Human Rights Group in Toronto. He similarly advises employers across a broad range of industries on workplace matters, including employment contracts, workplace policies, labor relations, and employee dismissals. He also has significant experience in litigation involving employment, labor, and occupational health and safety issues. And then we're also joined by Connie from our BC office in the Labor, Employment and Human Rights Group as well. And her practice focuses on employment and human rights litigation, where she represents organizations such as health authorities, universities, and school districts. She also regularly advises on workplace harassment, wrongful and constructive dismissal issues, and has appeared before the BC Human Rights Tribunal and the Courts of British Columbia. And with that, we will start our presentation. Okay, so today we'll be walking through the key legal issues employers are encountering as they implement or enforce return to office mandates. We will leave time at the end for questions, and we encourage you to submit questions as we go along. So I think it's well known right now that return to office mandates have become one of the most legally charged workplace issues over the past couple of years. We'll focus on termination considerations, accommodation obligations, and practical policy design tips. So our aim is not just to explain the law, although we'll be covering quite a few of the recent cases, but to help you spot issues early and to make more defensible legal decisions. So the agenda today will be the return to office landscape, requiring a return to office, human rights and return to office considerations, discipline and termination risks, unionized context considerations which differ from non-unionized contexts, and then designing and implementing return to office policies. So it's important to situate return to office mandates in the broader context of how workplaces have evolved over the past several years. So during the pandemic, many organizations shifted to remote work incredibly quickly, and the transition may not have been well thought out. It was often out of necessity rather than long-term design. And those arrangements were intended to address extraordinary circumstances. They were not intended to be a permanent overhaul of how work would always be performed in many cases. But as those circumstances have changed, and the pandemic considerations are no longer in effect, employers are now reassessing their operational needs. And many employers are now placing a renewed emphasis on in-person collaboration, mentorship, workplace culture, supervision, and team cohesion. And from an employer perspective, these are legitimate business considerations. And courts and arbitrators have generally recognized that employers and organizations are entitled to determine how work is structured to meet their goals. But that being said, at the same time, the experience of widespread remote work and working remotely during the pandemic has shifted employee expectations, which is why return to office decisions now require more careful planning and communication. So the issue for employers is not typically whether you can implement a return to work policy or whether you can reassess and change how work is performed. The question is, how do you do it in a way that aligns with your legal obligations and reduces unnecessary risk? So the question, as I mentioned, the question usually comes up. The most common starting question that we hear is, can employers require employees to return to the office? And in many, many cases, the answer is yes, but it is not automatic. And the discretion to require employees to come back to work is not unlimited either. So the employer's authority depends on a range of factors, including contractual terms, so the terms of the employment agreement, workplace history, statutory obligations, policy, the employer's policies, and for unionized workplaces, the most important factor is the contents of the collective agreement. So the key message is that, and I hate being wishy-washy because that's effectively always what lawyers do, but the key message is that return to office mandates are highly context specific. So the risk lies not just in the decision itself, but also in how that decision is implemented. So even though employers generally have the right to direct how and where work is performed, that discretion has to be exercised reasonably and in good faith. So a return to office mandate that is seen to be arbitrary, inconsistent, or poorly justified is more likely to attract legal scrutiny. Okay, so when making decisions concerning return to office mandates, employers have to consider a number of things. So when we're assessing whether a return to office mandate creates a legal risk, the starting point is always the same. It's what actually governs the employment relationship. And importantly, as I explained, the analysis looks different depending on whether the workforce is unionized or whether it's not unionized. So for non-unionized employees, we are usually looking at three things, which is the employment contract, policies, and past practice. So in employment contracts, if the contract clearly sets out the work location or reserves the work location to be the employer's discretion, that's often going to strongly support the ability to require a return to office mandate. If the contract allows remote or hybrid work or it's silent, that's where risk starts to increase. So in terms of setting expectations for future hires, the expectations in terms of work location should likely be included in the employment agreement or in a policy appended to an employment agreement. And as I said, the second place to look is policy. So a lot of employers had pre-pandemic policies that assumed in-person work, even if they weren't strictly enforced. Where those policies clearly reserve discretion over work location, that helps reduce risk. The issue that tends to arise is where policies were changed during the pandemic in a way that suggests that remote work was permanent, or where policies were never updated. And then the last thing that really needs to be taken into consideration when you're designing these or considering return to office mandates is past practice. And this is often one of the hardest pieces. So if employees have been working remotely for a long and consistent period, they may argue that remote work became an implied term of employment, and any changes could result in claims of constructive dismissal. Now, I think that risk is less so in the case of people who became remote as a result of the pandemic. But when we're talking about employees who have been working remotely for 15, 20 years, the considerations there are different. For unionized employees, the analysis is different. The starting point, again, is always the collective agreement. Past practice may also be relevant for unionized employees. And in many cases, employers will rely on the management rights clause of the collective agreement, which typically reserves the right to direct the workforce and determine how and where work is performed. So the key takeaway is that stepping back, the employer's position is strongest where there is clear contractual or collective agreement language that are supported by policies that reserve employer discretion. And it's generally weakest where remote work developed over time without any clear guardrails or clear parameters around it. And that's why documenting expectations and clearly communicating changes is really important when transitioning back to in-person work. With that, I will turn it over to Connie.
So I will be speaking on the human rights and RTO. Connie will jump in later, but on this point, this is a very common intersection between the return to office mandates. It intersects very closely with human rights legislation. So in Canada, employees have a fundamental right to be free from discrimination in employment. Federally regulated employers such as banks, airlines, and telecommunications companies are actually governed by the Canadian Human Rights Act, while most other employers who are not under the federal jurisdiction will fall under provincial or territorial human rights codes. Now, these laws prohibit discrimination in all aspects of employment, including hiring, promotions, training, and termination. And discrimination generally occurs where an employee experiences an adverse employment consequence or adverse treatment based on a protected ground. Common protected grounds, and by common I mean ones that you'll find throughout provincial or territorial human rights codes, and including the Federal Canadian Human Rights Act. These include race, sex, age, disability, religion, family status, and sexual orientation. While these are the common grounds, it's also important to note that each province has its own legislation and may include some unique grounds. So for example, for employers that are provincially regulated and in BC, a protected ground includes political belief. In Ontario, there is record of offenses, and in Quebec, there's a protected ground of social condition. So it's not sort of a one size fits all. Every province and every territory may have unique grounds depending on the code that's in force. And as I said, this means that, the core principles are similar across Canada. There are nuances depending on the jurisdiction, and it's important to note where you're located and what actual act governs you. So understanding these foundational principles for employers is critical because the duty to accommodate flows directly from the prohibition on discrimination. So if an employee is affected or adversely affected, rather, because of a protected characteristic, the employer may have a legal obligation to accommodate that employee up to the point of undue hardship. Now, today, we're going to primarily focus on two grounds that frequently give rise to accommodation issues related to work from home requests. One of them is disability, which covers both physical and mental conditions. And the other common one that we have been seeing in the case law is family status, which relates to caregiving obligations and other definitions depending on the how expansive the Human Rights Tribunal in that particular province has deemed the definition to be. So the legal framework for accommodation in Canada follows a two-step process. This process determines whether discrimination has occurred and what obligations arise for the employer. So the first step, there has to be what's called prima facie discrimination. So the employee needs to first establish a case of prima facie discrimination. This means showing three things. The first is that they have a protected characteristic under applicable human rights legislation. The second is that they experience some form of adverse impact in employment. This could be a demotion or a suspension and other forms of adverse employment consequences. And the third is that there has to actually be a connection between the protected characteristic and the adverse impact. Note that it doesn't have to actually be the entire factor. As long as the prohibited ground was a factor in the adverse impact, that gives rise to a prima facie case of discrimination. So I'll give you an example. So let's say an employee is disciplined for missing work due to a religious holiday, and the absence was directly related to their creed or religion, and there is some adverse consequence that the employee suffers, whether they're demoted for taking that off, or otherwise, this may establish a prima facie case of discrimination. The second step is the onus of the employer, and that is the duty to accommodate to the point of undue hardship. So once prima facie discrimination is established, the burden will then shift to the employer. The employer has to show that it accommodated the employee up to the point of undue hardship. And this is a particularly high standard. And we often get this question, what is undue hardship? And so the human rights tribunals across Canada have held that mere inconvenience or employee morale concerns, for example, do not amount to undue hardship. And we will discuss that further in a bit. So this two-step process ensures that employees are first protected from discrimination, while also recognizing that employers are not required to take measures that would fundamentally compromise their operations. So in some cases or certain cases, an employer can justify discriminatory standards if it's a bona fide occupational requirement. And the leading case on this is the Supreme Court decision of Maorian, which established a three-part test. So in order to prove a BFOR, there's three parts that have to be met. So the first is that the standard has to be rationally connected to the employee's job performance. The second is that this standard has to be adopted in good faith. And the third is that the standard is reasonably necessary, meaning that the employer cannot accommodate without suffering undue hardship. So, for example, just a vision requirement, for example, or to have a certain level of vision requirement for an airline pilot may be a BFOR because it is essential for safety. However, like I said, employers need to be cautious because BFORs are narrowly interpreted and require strong evidence. In a human rights complaint, if the responding party, i.e. the employer, puts forth a reasonable explanation, it's often open to the employee to then establish that this explanation is just a pretext and that the real reason or motivation for the impugned action, policy, or behavior is actually discriminatory. So, just to be cautious that while BFORs can be used by employers in certain situations, they are narrowly interpreted and strong evidence is certainly required. So to get a little bit more into detail on what actually is undue hardship, and to take Gillian's point, we lawyers like to always talk about a case-by-case assessment, and this is sort of one of those times. And so what may satisfy the duty to accommodate in one workplace or particular situation may not satisfy the duty in another workplace or situation. So what constitutes undue hardship is truly determined on a case-by-case basis. So if we look at, for example, financial costs, human rights tribunals and authorities have said that the employer's operations have to be seriously affected. The actual nature of the employer's operations would fundamentally change. Or in certain cases, this company would cease to operate. So those are examples of financial burdens that could amount to undue hardship. And now the guiding principle in the law of accommodation is that an employer is required, like I said, to accommodate to the point of undue hardship, but it is a high threshold. And so the case law is clear that both employers and employees need to work together in trying to find a solution, and they both have to be open to a variety of measures that are reasonable. And, the employee seeking an accommodation, should not expect a perfect solution. However, the employer has to consider a wide range of options and to be able to show what actual accommodation options were considered in order to meet its obligations under human rights law. So now I'm just going to discuss a fairly recent case involving accommodation and the duty of accommodating up to the point of undue hardship. So this case was a federal court of appeal case, and it was an appeal for a decision from a decision of the Federal Public Service Labor Relations and Employment Board. And this is a typical kind of claim where remote work was denied or taken away. So to get into the facts of the case, so the griever was a prosecutor who was actually employed with the Public Prosecution Service of Canada and had worked from home 2 days per week since sometime in or around the mid-2000s. That's what the facts had said. She was a woman, a Jewish woman with childcare obligations, and claimed that the telework arrangement that she was currently a part of was necessary to perform her religious and caregiving responsibilities. In 2016, her employer advised her that this telework arrangement was no longer feasible, as it restricted the work provided to her. So the griever claimed discrimination on the basis of disability, religion, and family status, which are three of the most common grounds that employees often claim with respect to return to office mandates. So the Federal Court of Appeal dismissed the application for judicial review in this case and upheld the Federal Public Service Labor Relations and Employment Board's denial of the griever's discrimination claim. The key aspect of the religious discrimination claim was that the griever had responsibility, for example, for lighting the Shabbat candles at sundown. The employee didn't want to stay home on Fridays, but she was prepared to let her leave early to attend those obligations. But the griever's evidence was found not to be credible. She had not shown that she had made reasonable efforts to meet her childcare obligations through reasonable alternatives. And the griever was insisting on this sort of perfect or preferred accommodation of staying home on Fridays when the employer gave her other options. And sort of the key takeaway here is that generally speaking, if there are suitable accommodations provided and the employer has worked towards that, employers are certainly not required to facilitate mere preferences for remote work or the perfect accommodation. It's a case-by-case basis, and the employer needs to simply make sure that they are providing reasonable accommodations in the circumstances, but it doesn't necessarily have to be the preferred or perfect one. And with that, I'm going to hand it over to Connie to discuss the disability accommodations in the context of remote work.
Thanks, Joseph. So on disability accommodation, so what's a disability under the law? Disability means any previous or existing mental or physical disability and includes disfigurement and previous or existing dependence on alcohol or drugs. So all federal and provincial human rights legislation includes physical and or disability as a prohibited ground of discrimination and is subject to statutory exemptions or defenses. Under the Canadian Human Rights Act, disability is defined as any previous or existing mental or physical disability and can include disfigurement or dependence on alcohol or drugs. This is not necessarily the definition across all the jurisdictions. This is under the Canadian Human Rights Act. Discriminatory practices under the Act include both discriminatory practices based on the prohibited grounds and the effect of a combination of prohibited grounds. Retaliation for making a discrimination complaint based on any aspect of disability is prohibited. Physical disabilities can vary greatly in severity and how they impact their ability to work. These physical disabilities can be permanent or temporary, episodic, or progressive in nature. On the other hand, human rights adjudicators have consistently held that commonplace temporary illnesses that are short-term, non-chronic, and do not significantly impair an individual's ability to perform their work is generally not considered disability requiring an accommodation. For example, if an employee has the cold or flu or even recovering from surgery, this is usually not going to be considered a disability. Similarly, minor ailments such as colds or temporary discomfort generally do not trigger the duty to accommodate. The condition must be a significant and ongoing impact on the employee's ability to work. With that said, if a temporary illness results in long-term significant or recurring impairments, such as complications arising from surgery and so on, it may fall under the definition of a disability and trigger legal protection. Oops. So under the Ontario Human Rights Code, the definition of disability is quite expansive. This list is not exhaustive, but can include visible and non-visible, mental and physical, and does not need to be permanent, and includes the fact that a person used to have a disability, and includes the perception of a disability. British Columbia is a bit different. Physical and mental disability is a prohibited ground of discrimination under the British Columbia Human Rights Code. But unlike Ontario, British Columbia doesn't actually have a definition of disability under its code. In a recent case from the British Columbia Human Rights Tribunal, the tribunal observed that it will interpret disability liberally to achieve the purposes of the code. So it doesn't want to define it strictly, but rather it will look at it on a case-by-case basis. It reiterates that the purpose of the code is to remove barriers that people may face in certain areas of daily life because of their disabilities. When considering if a condition is a disability, many of the same factors apply as in other provinces. So the tribunal considers the degree of impairment, any functional limitations, the social, legislative, or other response to that impairment and or limitations, whether the condition entails a certain measure of severity, permanence, and persistence. A condition does not have to be permanent to qualify as a disability. However, normal ailments also do not qualify. And just because a person is on medical leave from work due to a medical condition does not mean the condition will automatically amount to a disability. So very similar to Ontario. Some case examples. This one is from Ontario, from the Human Rights Tribunal of Ontario. This recent case dealt with a remote work request in the context of an employee's disability. So in this case, the HRTO, which is the Human Rights Tribunal of Ontario, dismissed a probationary employee's discrimination claim with respect to employment because of disability. The facts are, this employee began their 6-month probationary period with the employer respondent in July 2019. And soon exhausted her wellness days due to frequent absences due to physical health conditions, and which includes a generalized anxiety disorder and iron deficiency. After raising health concerns and requesting accommodation in the form of paid time off due to her and asking for work, like ability to work from home, the employer's disability management team sought medical information and obtained an independent medical review, which found no support for working from home or for the frequency of absences. During the same period, the employee's manager documented ongoing performance issues and continued absenteeism. The employee's employment was terminated on December 12, 2019, shortly before her probationary period ended, with the employer citing that her performance did not meet the role's expectations. So, the HRTO ruled that the applicant did not meet a prima facie case for discrimination. So while the termination of the employee's employment might have imposed a disadvantage or adverse impact, the employee's disability was not a factor in that impact. Medical evidence indicated that the employee's restrictions were with regard to walking, standing, and lifting, with no indication of restrictions on sitting and driving, issues with cognitive abilities, or that there was any need to work from home. The HRTO found that the employer nevertheless discharged their duty to investigate because a potential accommodation arrangement was considered and a thorough investigation was conducted. Some excerpts from that case. At paragraph 87, I heard evidence that the applicant had a protected characteristic under the code to the extent that the MCR showed some disability. However, it was not disability that would be impacted by the duties of the applicant's job. Paragraph 88, the prohibited ground or grounds of discrimination need not be the sole or the major factor leading to the discriminatory conduct. It is sufficient that if they are a factor. However, I did not hear evidence that on the balance of probabilities that could prove that the disability was a factor in the applicant's termination. Paragraph 89, I did hear a significant amount of evidence about the applicant's performance issues and absenteeism, which I found to be reliable and credible and supportive of conclusions. I heard evidence of the applicant's lack of cooperation or collaboration with respect to their meetings with the disability management consultant, and that the applicant had not been clear about their needs in terms of frequency and duration of absences. I also heard evidence about the applicant's lack of cooperation or collaboration with respect to their manager's attempts to inquire into the applicant's needs and provide support. And lastly, paragraph 91, while I accept that the applicant's termination may have caused them to suffer a disadvantage or adverse impact, I find that even if they had a protected characteristic, disability, that it was not a factor in the disadvantage or adverse impact. So this is another case arising from Ontario. In this case, the complainant was a teacher from the London District Catholic School Board. She alleged discrimination in employment based on disability. The complainant was diagnosed with vestibular dysfunction, and she experienced symptoms such as dizziness, nausea, and hypersensitivity to light and noise. She provided support from her physiotherapist, which stated that she required a quiet, non-distracting work environment and could not drive further than 2 kilometers outside of her familiar environment. The complainant communicated her preference to work from home, but also said she was open to another working environment provided that it met her needs. The board denied her request to work from home, but also provided an alternative work location that met her restrictions. The complainant later provided medical that she could not be in a car as driver or passenger for more than 3 kilometers, could work in a school if the office was quiet and had natural light, and needed to be able to work from home when symptomatic. It was recommended that the best option to meet the applicant's restrictions was to work from home, but indicated that if this was not possible, she could travel 2 to 3 kilometers from school or to a school. While the employer originally provided a workspace that met the complainant's restrictions and requirements, it later notified the complainant that this workplace was no longer available and that the only alternative was a space that was 6 kilometers away. It also rejected the complainant's request to work from home while symptomatic and required her to take a sick day even if she was working. So the tribunal found that the respondent had breached its duty to accommodate by not providing a work location within her driving distance limitations. The tribunal also ruled that the respondent could have accommodated the complainant by allowing her to work from home while symptomatic. It would not have amounted to undue hardship to do that, and so the tribunal found that the respondent breached their duty to accommodate. Now moving on to the topic of family status accommodation. So across Canadian jurisdictions, there are several legislations that includes family status as a prohibited ground of discrimination. So family status is a prohibited ground of discrimination under human rights legislation all across Canada, but the terminology might be different. So for example, in the Northwest Territories, the terms family status and family affiliation may be used. In Quebec, the term civil status is often used, which includes family status. Most commonly, family status discrimination claims arise where an employee has a family-related obligation, such as childcare or elder care, that conflicts with the employee's ability to meet workplace standards. Family or marital status discrimination can take the form of direct discrimination or indirect discrimination. So direct discrimination occurs where an employer adopts a practice or rule which on its face discriminates based on family status, for example, an anti-nepotism policy. Indirect discrimination occurs where a policy may be neutral or is a standard, but it has an adverse effect on an individual because of their family status, and that's not a similar adverse impact on other members of the workforce. So for example, fluctuating hours of work that could affect the employee's ability to secure child care arrangements. So here's some definitions. There's no definition in BC, unfortunately, and the Canadian Human Rights Act similarly does not define family status. Ontario, under Section 10(1) of the Ontario Human Rights Code, says family status means the status of being in a parent and child relationship. However, there's virtually unanimous agreement across Canada that family status incorporates parental obligations such as childcare, even where there's no firm definition in the legislation. The term family has been interpreted liberally by courts and tribunals, often including relationships that are not articulated in the statutory definition. So the Ontario Human Rights Tribunal and Canadian Human Rights Tribunal have confirmed that family responsibilities that arise from elder care also fall within the protected grounds of family status. And some case law. So in this case, which arises from the Human Rights Tribunal of Ontario, the HRTO upheld an application where the applicant employee alleged discrimination with respect to employment because of family status and reprisal or threat of reprisal. This employee worked in sales and was based in the field. Beginning in August 2020, the employee requested accommodation based on family status in order to care for her mother with cancer. The employer accommodated the employee by allowing her flex time to attend appointments with her mother during business hours. 1 month after granting this accommodation, the employee was actually placed on a performance improvement plan, which was issued in September 2020. In October 2020, the employee was told to report to work at the head office. The employee requested further accommodation based on family status, as she was still caring for her mother with cancer, who also had a broken wrist at the time, and she was engaging in childcare for her son, who was attending online school. So this, again, 2020 is the pandemic year. The employer advised the employee that she could not continue to flex her time to attend appointments with her mother, but they wanted her in the office when she was not with a client. The employee continued to work from home, and the employer did not communicate with her after rejecting her second accommodation request until she was dismissed 5 weeks later. In upholding the application, the HRTO found that the employer's decision to bring the employee back to the office despite her familial obligations constituted adverse treatment on the basis of family status. Working in the office was not a key part of the employee's role, and most staff were home-based since March 2020 due to COVID-19 anyway. The HRTO also found that the employer failed to meet the duty to inquire. The HRTO dismissed the employer's argument that the employee was seeking perfect accommodation, as they did not offer any alternative accommodation solutions other than the flexibility to attend medical appointments during working hours. The employer did not ask for further information in support of her accommodation request, so to better understand the care the employee's mother needed or what obligations she had. The employer's decision to cease communication with the applicant after they did not comply with the requirement to attend work in office was also a failure in their duty to provide procedural or substantive accommodation for the applicant's family status. The employer's conduct in issuing a performance improvement plan soon after the accommodation request, reducing communication, denying opportunities previously available to her, and terminating her employment constituted reprisal linked to her attempt to assert her rights under the Ontario Code. She was ultimately awarded $25,000 in general damages and approximately $75,000 in lost wages. Some important takeaways from these lessons: the duty to accommodate is cooperative and collaborative, which means that the employer and the employee need to work together to facilitate accommodation. How an employee's restrictions and limitations may be accommodated is an issue to be determined by the employer. Accommodations must align with the employee's restrictions. And in-person work is not automatically a bona fide occupational requirement, meaning that it's a requirement by default in any workplace that employees must be working in person. Further takeaways, elder care obligations may also engage family status discrimination protection. The accommodation process must be meaningful, and the legal approach does vary by jurisdiction. Moving now to the topic of discipline and termination risks. So the big one is constructive dismissal claims. When dealing with non-unionized employees, the biggest risk associated with return to office policies or denying requests for alternative work arrangements is that the employee might bring a constructive dismissal claim. Constructive dismissal arises when an employer unilaterally changes an essential term of an employee's employment without notice or reasonable notice, which the employee may not agree with, and may constitute a fundamental change in the employment terms. Where employees are contractually entitled to work in a hybrid or remote format, were hired on the basis of working in a hybrid remote format or have been working remotely for an extended period of time, this format could constitute an essential term of their employment. So case law provides examples of where conduct that approaches a breach of an essential term of an employment constitutes constructive dismissal. So in this case, which arises from the BC Court of Appeal, it involves a return to work policy that was successful and that the employee received a successful result. So in this case, the respondent on appeal, Carolyn, worked at Cressy Construction Corporation for 18 years, starting in 2005. She began a flexible work arrangement in 2013 following maternity leave, and in 2019, she began a remote work arrangement due to the COVID-19 pandemic. Carolyn continued in the remote working arrangement at a full-time capacity. In 2023, she met with the vice president at the company regarding a raise that she had been seeking since she received a promotion in 2018. In that meeting, the VP directed Carolyn that she was required to return to office full-time. She resigned from this position, citing constructive dismissal due to the requirement to return to in-office work after remote work had been an essential term of her employment contract. So the court found that she was constructively dismissed. The court determined that when the employer unilaterally changed Carolyn's contract by requiring her to return to in-office work after agreeing to the term that Carolyn was permitted to work remotely. The judge also found that, too, this unilateral breach changed a fundamental part of Carolyn's employment contract since she had been working from home for 3 years, and that this change would have significantly altered her lifestyle with little to no notice. Another example arises from the Alberta Court of King's Bench. It's a similar recent decision dealing with constructive dismissal that's been recently reported from Alberta. In this case, the plaintiff, Nichols, worked as an office manager in a vein clinic starting in 1986, up to her resignation, citing wrongful dismissal into 2023. That's a total of 37 years at this workplace. So she largely worked from home for the entirety of her 37-year career, but attended in office as needed or requested. After the clinic changed ownership, it launched a return to office initiative and insisted that Nichols return to full-time work in office. Nichols sought counsel to attempt to negotiate a 2.5-day in-office schedule, but the clinic insisted on reserving the right to increase the amount of full-time in office in the future. And this is towards that policy. Eventually, Nichols resigned, citing constructive dismissal. The judge found that she had been constructively dismissed. Nichols had been working from home for 37 years when the new owner imposed the return to office policy with 3 months' notice. Given that she'd been working under this arrangement for 37 years, it was determined that it was a fundamental part of her employment contract, and its unilateral modification by the employer was a fundamental breach. And another example arises from Ontario. The plaintiff in this case began working with the defendant care home in 2018 on the terms of an oral contract. She never actually received a written contract. In 2020, after numerous promotions, she was informed by her husband that he would be stationed at a military base in Belgium. She informed her employer, and they discussed how she'd be able to continue working for the company remotely from Belgium. She moved to Belgium with her family, but continued working in her position remotely. Her employer hired new staff and began limiting her working hours. Ultimately, in March of 2022, her employer requested that she return to an in-office position to supervise the new employees, or if she doesn't want to do that, then she must resign. She resigned and brought a claim for constructive dismissal. The judge found that she was constructively dismissed. She and her employer discussed continued work before she left for Belgium. Her evidence was that her staffing was critical to the employer, so that a remote work system would not be an issue. The judge found that given the conversation between the employee and the employer, the remote work system became a fundamental term of her continued employment with the defendant. And since the employer's return to work letter breached this term, it amounted to constructive dismissal. Some key takeaways. Recent case law shows that there are limits to when an employer can recall employees to work. So where the employer or the employee's employment is conditioned on an alternative work arrangement, or an employee has been working through an alternative work arrangement for a significant amount of time, a request to return to work must acknowledge these circumstances. Employers should be aware and keep track of employees' work arrangements and whether they were hired under a specific remote or hybrid work arrangement. If the employer plans on recalling an employee who has been working remote or hybrid, they must give the employee reasonable notice. If an employer approves an employee for alternative work arrangement, they should inform the employee whether it is temporary or permanent and whether they can be recalled into the office in the future. And now I'll turn it back to Joseph to discuss unionized workplace considerations.
Thanks, Connie. So with respect to unionized workplace considerations, this sort of, it goes back to our original, thesis and the key question of what governs the employment relationship. So unlike non-unionized employees, unionized employees derive their rights in the workplace primarily from the collective agreement rather than individual contracts of employment. The collective agreement establishes standardized terms and conditions of employment for each respective bargaining unit and displaces individual contractual negotiations. So unlike for non-unionized employees where we're governed by the terms and conditions of an employment agreement, unionized employees have their rights and obligations derived from a central collective agreement, which binds the union, members of the bargaining unit, and the employer. So the employer within these collective agreements or within the collective agreement generally has a management right to determine the unionized employees' work arrangements, such as work location and availability of hybrid or remote work. That right generally rests with the employer. However, another word that lawyers love to use, however, if there is language in the collective agreement regarding work arrangements, then employer decisions must be consistent with the collective agreement. So the collective agreement is sort of the governing document. And if there is any language in there that has something with respect to work arrangements, employers must abide by it. So if the employer is required to make a discretionary decision under the collective agreement related to work arrangements, it has to be exercised in a way that is consistent with both the collective agreement and the reasonable exercise of management rights. And this is a very common question we get sometimes from unionized, employers that do have a unionized workforce. But the concept of constructive dismissal, much like what Connie just discussed, is largely inapplicable for unionized employees because, once again, all fundamental terms of a unionized employee's employment stem from the collective agreement and not individual terms and contracts of employment. So, in other words, a unilateral change, which is what's required to occur for a constructive dismissal, is not characterized as constructive dismissal for unionized employees, but is instead characterized as a potential violation of the collective agreement. And this collective agreement violation, or alleged violation rather, would be subject to the grievance process and arbitration that is set out in the applicable collective agreement. So it's a little bit different from the dealing with non-unionized employees. So a lot of the case law that's been developed in this area has been dealing specifically with public sector unions. And the gist of most of this case law is that there's not one way to assess an employee's request for an alternate work arrangement, which again is also sort of the central theme of this presentation of a case-by-case analysis. So again, if the collective agreement contains specific language on what considerations that an employer must take into account, then those considerations should be addressed by the employer when considering an employee's alternate work arrangement. However, even when there is sort of specific language, there are still some general considerations and guidelines that the employer may want to consider when considering a unionized employee's request for an alternate work arrangement. So once again, just to clarify, this case law has been tested primarily in the public sector, and some guidance for employers in the public sector comes from recent decisions that have applied what's called the fourfold test. And it has been adopted by recent arbitration decisions, like I said, specifically in the public sector. And it's unclear yet if this test applies to private sector unions. But the general purpose of this test is to try and mitigate the risk that when employers are deciding on whether to approve alternate work arrangements, that they're not made in a way that is arbitrary, discriminatory, or in bad faith. Once again, while this test is sort of general, there also may be considerations when an employer gets an alternative work arrangement request, depending on the wording of the applicable collective agreement in place. So some collective agreements actually have an alternative work arrangement procedure and actually have sort of text that says you need to consider certain factors. But the general nature of the fourfold test is that the decision must be made in good faith and without discrimination. It has to be a genuine exercise of discretionary power, as opposed to sort of just some rigid adherence to policy or practice. Consideration has to be given to sort of the merits of the individual AWA request that's under review, so the actual employee's request. And all relevant facts must be considered and irrelevant considerations must be rejected. Once again, this is just a general test. So far have only been applied in the public sector, and it's certainly subject to whatever the applicable collective agreement states. So the case law, again, dealing with public sector unions generally, has provided some sort of considerations that employees may want to consider. So, for example, employers may want to consider the extent to which the employee would benefit from an alternative work arrangement in granting it, what type of supervision the employee needs. If they're going to be working remotely, is it a situation where they require constant supervision, or do they just need, email support? If the employee can actually attend on site if needed, for example, if they work in a safety sensitive position or a position that requires travel on site if something urgent comes up. Some factors being related to the proposed arrangement, where the employee plans to actually work on out of office days, right? So if that location is safe and appropriate, if it's a job, for example, that deals with confidential information, right, and you have someone working in a busy household, that might be a consideration when considering the alternative work arrangement. The cost of getting resources for the employee at their home office if they're going to work remote, and also, a common one, especially these days, is the reliability of internet. For example, if they live in a remote area where internet's not accessible, these are considerations that an employer should thoroughly look at and take into account when they're planning on granting the AWA request. And once again, just to add the applicable caveat here, these considerations are, first of all, not exhaustive and are certainly subject to the language of the applicable collective agreement. But again, in our view, they may be helpful when considering whether to approve or deny alternative work arrangements, and also, helpful when providing actual reasons to that employee to evidence sort of a degree of reasonable exercise of discretion from management. And there are also factors related to the employer that may be relevant with respect to, considering alternative work arrangement requests. Whether the actual alternative work arrangement will free required space in the office, whether the employee will be more or less productive at home or at the office, if there's any impact on employee morale. So collaboration and team building is a very common justification that employers use. And if it's an environment that would benefit from that, that is a consideration for the employer. Once again, whether the loss of supervision will actually impact in performance on the employer's end. And, again, if the employee's work must be performed at a specific location, the general theme of this is, when addressing the employer's considerations, the employer should acknowledge both the benefits and detriments that may impact them as a result of the alternate work arrangement request. And again, these are non-exhaustive and subject to the applicable collective agreement that's in place. I am now going to turn it over to Gillian to discuss flexible work arrangements under the Canada Labour Code for federally regulated employers.
Thanks, Joseph. I won't talk about this topic for too long, but again, as Joseph said, the Canada Labour Code specifically applies only to employees that are federally regulated. So it is not applicable to provincially regulated employees. Federally regulated employees are only about 10% of Canadian employees, but a lot of large organizations such as banks, airlines, railways are federally regulated. And dissimilar to a lot of the provincial employment standards legislation, the Canada Labour Code actually specifically includes provisions regarding flexible work arrangements. So I wanted to briefly cover the requirements under the legislation so that employers know how they need to respond to these flexible work arrangements. So the stated purpose of the legislation is that the flexible work arrangements serve to provide changes to employment terms that allow employees to achieve a better work and home life balance. The flexible work arrangement requirements under the Canada Labour Code are not only in respect of remote or hybrid work, and they cover the location of work, such as working from home or a satellite location, the scheduling of work hours, such as modified work schedules or split work shifts, and the number of hours, such as part-time arrangements, job shares, reduced hours. And again, the stated goal of the legislation is to benefit both the employee and the employer by decreasing absences, improving employee health and satisfaction, and improving employee retention. Whether it actually does that is up for debate. So in terms of who can submit a request for a flexible work arrangement, so the flexible work arrangement provisions only apply to employees who have been continuously employed for 6 months. So individuals who have been employed for less than that cannot make a flexible work arrangement request, or if one is made, it can be denied. And requests are limited to 3 specific categories. So the requests can be related to requests to alter the number of work hours, the work schedule, or the location of work. And there's specific requirements. The requests have to be submitted in writing. And in the request, the employee is required to include specific information, which includes their name, the date of the request, a specific description of the arrangements they're requesting. And if it's a temporary arrangement, they're requested to state the start date and the end date of the arrangement, and also the expected effects on the employer of the arrangement that they are requesting. So they're actually required to consider the specific impact on the employer. So employers have to provide a response to requests for flexible work arrangements in writing, and that has to be done within 30 days of receipt of the request. And employers have one of 4 possible recourses to responding to a flexible work arrangement request under the code. So they can approve it as is, so as the employee has requested it. They can approve it in part, so accept parts of the request but reject others, or they can propose an alternative. So, for example, if the request is for an employee to work to fully remote work, the employer can propose 3 days remote, 2 days in office, or some variation. And then lastly, the employer can deny the request, but they have to provide adequate justification for the denial that's tailored to the individual request. Importantly, the employer can't reprimand an employee for making a request or subject them to any form of reprisal or discipline for making the request. If a request is made and the employer specifically targets or reprimands the employee just because they actually made the request, that can result in a reprisal complaint to the Canada Industrial Relations Board, or an employment standards complaint too under the Canada Labour Code as well. But the discipline and reprimand has to be specifically in respect of the request for a flexible work arrangement. If there are other things happening on the side, like performance issues, etc., the employer can discipline in respect of those. You just need to ensure that the discipline is specifically tied to those other performance issues and unrelated to the flexible work arrangement requests. So to justify a denial, there's actually rationales provided in the code that an employer has to meet to deny a flexible work arrangement request from an employee. So an employer has to be satisfied that the requested arrangement would result in one or more of the impacts listed on the screen here. So the requested change may result in additional costs that would burden the employer. The requested change could have a negative impact on quality or quantity of work, the ability to meet customer demand, or the performance of the workplace. The employer must show it doesn't have to meet all of these, I should say. It's one of these. The employer cannot reorganize work among employees or hire additional employees to manage the change. If an employee moves to a certain work arrangement, there wouldn't be enough work available for the employee if the change was granted. So for example, if an employee's tasks, like 75% of them have to be completed in office, they simply cannot be performed at home, and only about 25% of their duties and responsibilities could be performed at home, I think you would have a very good rationale for saying, well, there's not 25% of the duties and responsibilities is not a meaningful amount of work or enough work. So that would be a basis for a denial. And then the last reason for denial is the requested change does not meet the criteria to request an FWA. So they don't have 6 months of continuous employment, or they don't meet one of the criteria, or asking for a request that falls outside the parameters of the code. Anecdotally, it appears that the labor program is inclined to accept an employer's rationale that remote work would impact the quality or quantity of work or the ability to meet customer demand. We have seen a number of flexible work arrangements where the labor program has accepted the employer's rationale, particularly where it relates to providing customer service. And again, if an employee disagrees with the employer's denial or with the employer's response, they are entitled to file a labor standards complaint under the Canada Labor Code. Okay, so we'll touch now on how to properly design and implement a return to office policy. And again, there's no one size fits all here, but that being said, it's important to be informed when you are drafting or implementing return to office policies, because the policies can engage a range of legal issues beyond simple attendance expectations, which, as we've already talked about, could include constructive dismissal risks, accommodation obligations, and then, depending on which province you're situated in, jurisdiction or employment standards specific requirements. So we've just placed some tips on the screen for you, but for workplaces that are non-unionized employees, or if we're talking about a non-unionized employee group, we do generally recommend that employers should provide ample notice of return to office policies or other changes to working arrangements to reduce the risk of constructive dismissal claims, and also just to allow employees to make appropriate arrangements, whether it's in respect of childcare or housing arrangements, whatever it might be. There's no, again, wishy-washy answer, but there is no kind of bright line test for what is an appropriate amount of notice to provide to employees. The appropriate amount of notice is likely going to depend on a few factors, including how long they were previously working in a remote arrangement. If someone's been working in a remote arrangement for 20 years and their life has been kind of built around this remote accommodation, they likely need a longer leeway period than someone who only stepped into a remote arrangement as a result of the pandemic, and the expectation was never that they will permanently work from home. If you are hiring new employees and they are starting remotely or in a hybrid work arrangement, and that's not anticipated to last forever, or you want to ensure that they are aware that it may not last forever, the employment agreement should specify that any remote or hybrid working arrangement is temporary and is subject to change at the employer's discretion. That should be explicit in the employment agreement. And same within policies, you should explicitly reserve the right under employment contracts and policies to require in-person attendance. Even if there's a situation where the employee will be permitted to work largely remotely, but there are situations where they will be required for in-person attendance, such as monthly team meetings or meeting customers on a specified number of dates, those parameters should either be built into the employment contract, or there should be discretion built in so that the employer can say, well, it was set out in your employment agreement, or it was left to the discretion of the employer as to how frequently you had to come in. These policies should also be transparent about the accommodation process. So they should note that the work arrangements will be subject to legitimate accommodation requests. So the policy should be transparent about what the accommodation process is and explain how requests will be assessed, what information could possibly be required. The information that's going to be required depends on what the request is. If it's family status relative to a disability request, the requested information is going to be different. It should also specify who is going to review the request. If it's HR, it should probably specify that, and also how decisions will be revisited, or if there's going to be a right to reconsideration or anything of that nature. That information should be provided in the policy. Remember that failure to meaningfully engage the procedural duty to accommodate can risk legal liability. So you should take seriously and at least consider all requests for accommodation that engage human rights grounds such as disability and family status. So we've seen that when there is no consideration given to those requests, or kind of just a blanket denial, that those tend to go in the employee's favor. Be careful if you are revising existing contracts or you're changing long-standing work conditions. So unilaterally revoking long-standing work arrangements, even if they're unwritten arrangements, through a return to office policy can amount to the risk of a constructive dismissal. And then taking the time to familiarize yourself with any specific rules your jurisdiction has related to work from home and flexible work arrangements. So for instance, as I was just discussing, the Canada Labour Code has specific statutory requirements regarding flexible work arrangements. Then a well-informed approach helps employers ensure that the policy is tailored to legitimate business needs, of which there are many, and that it's implemented consistently and designed with processes for accommodation, reducing the risk of grievances, human rights complaints, and other disputes. And I think the importance of consistency is key here. So while individual factors have to be taken into consideration in accommodation requests, a return to office policy should be applied consistently, whether it's in respect of a specific business unit. It doesn't necessarily have to be across the organization because different business units could have different needs depending on what they do. But ensuring that in respect of a specific unit of employees, the policy is applied consistently, barring accommodation requests. And so this is just kind of a cautionary tale about changing remote work environments in a situation where someone had a very long-standing arrangement. So this is an Ontario case from 2017 where the employee had actually initially quit her job at the employer. The employer was located in Vaughan. So she quit back in 1992 when she relocated to Waterloo. And then a few years later, a vice president at the employer actually recruited her to return on a temporary basis and then actually persuaded her to accept a full-time offer on the condition that it was a hybrid work arrangement. So for 22 years, the employee worked at home 3 days a week and 2 days a week in the Toronto office. Again, there was no written term that documented this arrangement. And there was no written term that documented the employer's right to recall the employee. So it went both ways. Neither the employer or employee had anything in writing kind of specifying the arrangement and whether the employer had the discretion to bring her back into the office on a full-time basis. In 2015, the employer was actually purchased, and the new employer, it's the same employer, but the new employer told the plaintiff that she could no longer work from home in 2017. So the plaintiff claims constructive dismissal, and the court found in her favor. The court said they effectively found that the employee's work from home arrangement in this case was essential to her employment contract. So effectively, she would not have accepted employment with the employer or new employment with the employer had this remote work and this hybrid work arrangement been in place. And they found that changing that fundamental term amounted to a unilateral breach of the employment agreement. So some of the factors that the court considered here was that the distance from Waterloo to the Vaughan office was 110 kilometers of driving distance, which meant that she would be driving on the 401 and the 407. If any of you are from Ontario and have driven on those roads, you know that is not pleasant in rush hour. But the court essentially found that it would add approximately 3 hours to her workday. They also found that the cost of that would not be insignificant. 220 kilometers of driving in addition to toll charges, they found would be a relatively significant cost for the employee. They also found that, again, there was nothing in writing between the parties regarding the arrangement. There was an oral agreement that induced the plaintiff to return to work for the defendant, and the performance of that term of the agreement continued for 22 years. So the court found that her ability to perform her work from her home office 60% of the time was an essential term of her employment agreement. And the court found that there was no doubt on the evidence before it that the employer had unilaterally breached the term of the agreement, thereby constructively dismissing her. And I'll only touch on this briefly, but designing and implementing return to office policies in the unionized context is, again, it's very different. Like, we can't distinguish enough how different the unionized versus non-unionized context here. Again, return to office policies in the unionized context have to comply with the collective agreement. As in any case with accommodation requests, decisions should be made on a case-by-case basis and tied to operational needs and consistent with the collective agreement. Each request should be considered in good faith, again, based on collective agreement requirements and the employee's circumstances with clear reasons documented for the decision. I think it's true that in any case, there should be clear reasons documented for the denial of any form of request. And with that, I think we will now turn it over to a few questions.
So I have one discussion question that I've gotten, when does a request to stay remote become a legal accommodation issue rather than just a preference? Again, so like we talked about, where an employer's workplace standards creates an adverse effect on an employee based on a protected ground of discrimination, that's when the duty to accommodate is triggered up to the point of undue hardship. For example, if someone says, I have X disability that is preventing me from, fulfilling the duties of my role, and this disability would be mitigated by me working from home, and the policy to return in office is affecting me, that's when the employer has an obligation to accommodate. And of course, that involves working with the employee to try and find a reasonable accommodation, whether it's, working from home certain days or if it's fully remote. This can involve, medical evidence is important, asking the employee, for example, to get their physician to fill out a functional, limitations form that details their functional limitations without necessarily dealing with the diagnosis. And in the case of family status, for example, a sort of similar situation where an employee can say, look, I can't be in office because I have an obligation to care for my child. That may trigger the duty to accommodate. However, again, the employer would work with the employee to basically say, okay, well, how many days do you need to be off? Have you tried, are there any other alternative arrangements that you've made? So again, it's an iterative process between the employee and the employer. And again, mere preference does not have to be accommodated. However, if there is a protected ground involved, and the employer's policy or requirement that the employee work in the office is creating an adverse effect, or they have said it creates an adverse effect, that's when the duty to accommodate is triggered. So mere preference, no, but if it's something based on a protected ground, that's when the duty is triggered, and that begins sort of the iterative process of working with the employee to figure out a reasonable accommodation up to the point of undue hardship.
So I'll cover the next question, which honestly is probably one of the questions that I see the most frequently, and it's how do you deal with and assess accommodation requests that are based on mental health, so anxiety or neurodiversity, where the limitation relates to the office environment rather than the actual job itself. So honestly, accommodating mental health considerations is one of the hardest things to do. But human rights protections do cover both physical and mental disabilities. So if there is documented evidence in respect of mental health disability, that doesn't change the accommodation analysis. You do still need to accommodate. So you need to ensure that you follow accommodation policies and respond to all requests for accommodation with respect. That being said, you're entitled to ask for sufficient medical information to support the mental health disability as well. So I think a lot of employers shy away from or are scared to ask for additional information in respect of mental health disabilities. And while you may not be able to ask for diagnostic information and stuff like that, you are entitled to sufficient information to understand how you can appropriately accommodate this person or whether an accommodation is even necessary. If someone just states, well, I have generalized anxiety disorder without providing medical information supporting that and how it affects their ability to attend the office and their restrictions and limitations, and you've asked them a number of times to provide medical information, then the accommodation analysis may be shut down and you may have no further obligations, but it really depends on the information you get from the employee. That being said, all forms of mental health disability those requests should be considered. Like, you shouldn't just do a blanket denial of certain requests. So there's a very recent decision from the Ontario Human Rights Tribunal, which held that the respondent employer discriminated against a griever who was suffering from a chronic sleep disorder, emotional dysregulation, anxiety, depression, and panic disorder when it rejected his work from home accommodation request and instead placed him on sick leave. So you have to adequately assess the request being made to you, particularly when it involves mental health disabilities, because those are definitely the trickiest to deal with. So you should take steps to reduce the risk of litigation through well-informed and implemented policies. And this could lead to saving time, money, and stress, and lead to better workplace environments as well.
Excuse me. I can answer the third question that we received. And that question is, at what point does a return to office requirement create constructive dismissal risk? And so in relation to this question, as we've seen from the case law, it really depends on each case and what the arrangement was. So at one extreme, we had a 37-year employee who had a work from home arrangement all her career, and then the business was bought out or changed management and she was required to come back. That's probably one of the most extreme examples of someone whose fundamental term of employment includes a work from home or hybrid arrangement. And in that case, requiring her to be in the office 5 days a week was very obviously a fundamental change in the term of her agreement. But generally speaking, it really does come down to what is considered a fundamental term of the agreement. And that doesn't necessarily only relate to what's written in the contract. It relates to how the parties perform the employment agreement and what has been done sort of in the past, for how long, that kind of thing. Fundamental terms can be written or implied as discussed. So therefore, let's say for the past 3 years, employees have been working remotely. It hasn't been communicated to them that it would be temporary. There's no issues with them working remotely. They get the work done. There isn't performance improvement issues. And generally, there hasn't been any discussions from management that they want anything to change. And then if suddenly the employees are required to go back to work, that could be risky for constructive dismissal just based on that kind of scenario. So when considering implementing a return to office requirement, it's important to consider whether remote work is part of their day-to-day work, how long they've been doing it. It's been written in their contract, and there's no language to say it's temporary or that they can be recalled back at any time, or whether it's implied in their contract and sort of how the parties have performed it. For future contracts going ahead, just to protect the employer from risk of constructive dismissal in this type of situation, it's important, as already discussed, to clearly state in their employment agreement if there's any kind of remote or hybrid opportunity that the employer reserves the right to recall employees back, if there's a business need for it, and that is communicated to the employees when they receive that contract. So everybody's clear that if the parties eventually perform it differently, that this requirement or this caveat exists.
And we just got another question from the audience about, the question was, if the employer and the employee are based in different jurisdictions, which jurisdictions governs? Again, it's context dependent, but almost always the usual answer would be that where the employee is situated. So if the employee is physically located in Ontario, generally the Ontario Employment Standards Act would apply. If an employee is physically located in BC, generally the BC Employment Standards Act would apply. So typically the legislation that governs is the legislation in the province where the employee is situated. And another question was, what about employees whose contract doesn't specifically state that there is a hybrid or a working location, but there is an employer policy in place? And again, I think that answer is context dependent. It would depend if this policy, like if an employee had previously been working remotely for 20 years and the policy was developed in year 19 of that work arrangement, it may potentially be constructive dismissal. It's really context dependent there. It depends when the policy was put in place, who the policy applies to, whether the employee was aware that they could potentially be recalled to work. So again, it's very context specific as to when an employee may be able to claim constructive dismissal. That being said, it's always helpful to have a policy in place. If the employment contract is silent on it, it's always helpful to have an employment policy in place that does specifically address hybrid work arrangements or when a return to office may be required. If that policy has been in place throughout the duration of the employee's employment and they were aware of it, it could significantly reduce the risk that they could claim constructive dismissal successfully. So short answer, always context specific, but a policy is always helpful because it kind of sets the standard across the organization or across a specific business unit, whatever it might be. So with that, just a few closing remarks. So thank you so much for your time today. Thank you both to Joseph and Connie as well, and to everyone for joining us. You will see the information on your screen here for CPD credits for Ontario, Quebec, and BC. And then links have also been added to the audience chat. If you don't get a chance to claim your CPD certificate today, they will also be sent next week. So thank you again for coming, and we really appreciate the attendance, and have a great rest of your afternoon.